Back to another Tuesday Tips at 2 here with the Goldbergs. This week it's going to be a sad episode. I'm going to tell y'all about the very preventable loss of hundreds of thousands of dollars, possibly even more. Totally preventable. What do they say? An ounce of prevention is worth more than a pound of something. Indeed it is. So here's the tale. I'm going to speak about a client, a very sad story, and I'm going to use no identifying information whatsoever so that I don't breach any confidentiality, God forbid. Here was a gentleman who came to us after a car crash, and he hired our firm after this car crash. At the time I thought, okay, car crash case, I can handle that. It turns out that after this car crash, he didn't just have certain injuries, he had some traumatic brain injury, which led to internal hemorrhaging, multiple hospitalizations, etc. For this type of case, a traumatic brain injury case, I'm not too proud to admit that I wanted a co-counsel to help me out. Co-counsel said, sure, no problem, let's do this, but first, do XYZ, get the records going, let's get some facts. Great, no problem. Started doing that, and in the process, timeline to file the suit was nearing. We had to file suit. So I started off the lawsuit, and right then, turns out that our client died. He died from these very same brain injuries, and that led to another hospitalization, more internal bleeding, and he passed. Very sad story. So then we had a lawsuit where I'm the attorney, but I don't have a plaintiff who's alive anymore. So I represent no one. In this type of situation, then the estate of the plaintiff owns the lawsuit. Here's where things got real tricky. Who's in charge of the estate? Who? If the client had had a will, which he did not, then the will would have stated so-and-so is the executor. He's now in charge of the will. And here are my beneficiaries, and the money from my estate goes to them. Oh, but he didn't have any money. He was just a working man, so he didn't think he needed a will. Wrong assumption. You never know when you're going to hit a jackpot in multiple directions. Lottery? Someone else giving you a big batch of money as a gift, or perhaps a bequest from their own will, or perhaps even a car crash. You just don't know. So there we were, no plaintiff, no estate. So I contact the plaintiff's, my former client's mother, and I say, we got to do something here. Can you be the independent administrator, meaning the person that's in charge of the estate that is not chosen by will, but instead is confirmed by court? She says, no problem, but then I learn all sorts of other details. The client had had children from previous relationships, and some of them were minors, okay? So now the estate code in Texas requires that the administrator be what's called dependent, meaning more oversight of the court, and also must be bonded just in case they screw over these children, God forbid, the beneficiaries of the estate. There's got to be a bond that the children can sue against. Okay, that's the law. It's a good law. It protects beneficiaries when there's no will whatsoever and the beneficiaries are children and can't protect themselves and have attorneys there. All good stuff. Well, here's the problem. The family, the mother that is, had bad credit, poor credit history. So no bonding agency would give her a bond. So she was not qualified to become the dependent administrator. Another sibling of the deceased plaintiff also had poor credit, so they couldn't be it. Then they're having difficulty in finding anyone in the family willing to take on this massive burden of representing the estate, dealing with numerous beneficiaries, several different mothers of the beneficiaries, all sorts of complications. And in the process, I'm then also trying to find a probate attorney to do all this and pay them. Oh God, it became a full-blown law school question on a giant law school exam, or possibly even the state bar exam, bringing in multiple areas of the law. And that's before we would even get to the case where then me and a co-counsel would have to tag team and pay an expert to look into the brain injury and bring on this case without our main witness there because he was deceased. All of this goes to make one single point. I don't care who you are. I don't care how old you are. It doesn't matter how much wealth you think that you have or are gonna have one day. You need a will. You need powers of attorney. because while he was there in the hospital, in and out of the hospital, his own mother was having difficulty in visiting him up until he signed a power of attorney. Unfortunately, he did not then sign a will. You need a durable power of attorney. You need appointments of guardianship. God, you just need these things. Wake up, get it done. Small investment that will have great big payoffs. Until next time, be well.